Tumelani sanibonani ninjani molweni. Today it's PVL Property Law, May, June 2022 examination. We are doing preparation for exam, and today we are starting. So those that are my subscribers, you must know that you'll be writing for 3 hours, and there will be many questions which will require you to read some big scenarios. So you must be really prepared for this one. Property law is not an easier module. Yeah, you can repeat it even 4 times. So question number 1, those that are following me, they know that I've already dealt with question number 1. Thanks for being part of my membership. And then today we're going to question number 2. And we're going forward with this question paper so that we'll redo as many question papers we can, so that when you go to examination, we'll be much prepared. Remember, they just take exams from the previous question paper. So it's very much important for you to attack the previous question papers. Today we are here to help you to attack the previous question papers. Question number 2, Mr. and Mrs. Ngubane are owners of the residential property bordering the Arabelle Golf Course. Mr. and Mrs. Ngubane's house has on numerous occasions been hit by golf balls. Their property was subjected to unreasonable high levels of intrusions by stray golf balls to the extent that the ability of the Ngubanes to use their property was severely affected. Mr. and Mrs. Ngubane erected a net around their property to prevent the stray balls from landing on their property. However, this did not solve the problem. Question 2.1, 3 marks. Identify and describe the nature of the conduct of members of the Arabella Golf Course towards Mr. and Mrs. Ngubane. So you identify and describe such a conduct, the nature of such a conduct. Okay, 2.1, let's go and see if we can find the answer. Very simple, in a simplified way. Before I answer that question, do you remember ILW? Of course, you remember Introduction to Law, right? Of course, you remember Introduction to Law. And if you remember Introduction to Law, in the ILW, there was some law balance interest. Do you remember? They said the law brings about a balance between interest of Jane and Karen. There are numbers of things which a landowner may not do and which will be a nuisance or cause harm to the neighboring property. The following are a few examples. Jane may not build a right up to the boundary of her land. There is a municipality regulation that prohibits this. She may not dig a ditch at the boundary because this will cause Carol's land to sink down. She may not cause excessive smoke on her land, for example, by lighting a fire, because this will be a nuisance and make life unpleasant for Carol. Carol also may not do these things. If either James or Carol commit such a prohibited act, then the law comes into operation. Jane and Carol will be forced to remove the nuisance to compensate the other one. Do you know? Now let's go back to the question. Now, this is the question. Identify and describe the nature of the conduct of the members of the Arabelle Golf Course towards Mr. Yes, they are doing the same. They are causing the nuisance to their neighboring, and you must not cause the nuisance. They are playing golf and they hit the golf balls, and those strays will be landing on their property. It's the causing of a nuisance. When you light up the fire in your house, it may be a fire, but you're causing, the smoke is causing nuisance to the neighbors. You are not allowed to do that. Another example that I would like to give you, people from Ekasi, Soweto, they have a tendency of building this, a double storage. Do you know? When you build a double storage, you must go and get permission from your neighbor that you are building those double storage. Even if you are building the back rooms, then you find that some of the rooms may be preventing maybe the neighbor or causing nuisance to the neighbor, or they may be shadowing in the house of the neighbor. So you must always get a consent for that, because if you don't have a consent, they can force you to demolish such a building. You must know this thing off by heart. So now we have already identified and described the nature and the conduct that they are doing towards Mrs. and Mr. Ngubane in a simplified manner using ILW book. But we can at least go straight to the property just for then number 2.2, we are going forward. Identify the remedies that can be instituted by Mr. and Mrs. Ngubane against the Arbella golf course. Identify the remedies that can be instituted by Mr. and Mrs. Ngubane against the Arbella golf course. There is no damage. It's just that they are causing. Although sometimes there is a damage to the property, which they have to claim the remedies. So it's very simple. Now let's read this. In neighbors' law situation, we distinguish between nuisance in a narrow sense and nuisance in a broad sense. In the narrow sense, nuisance occurs where a neighbor's right of personality or entitlement of use is infringed by, for example, noise or smell. This infringement does not necessarily result in damage, but rather in a personality infringement. The remedies are prohibitory interdict or a claim for delictual composition. Nuisance in a broad sense results in damage to property, and the remedies are prohibitory interdict or claim for delictual damages. We are done. That was easier as 5 marks for that. Just to talk about nuisance, and then you talk about the remedies like interdict and delictual remedies. Done. You get the 5 marks. This was the easiest marks in the examination. So let's go forward. Question number 3. Jacob and John are neighbors. Okay? Jacob is in the process of making renovations to his house. As a result, he decided to extend his house. However, the extension to his house unintentionally went over the border of his and John's property. John notices that a part of Jacob's building is built on his land. He is absent and contacts you for legal advice. Question number 1, 3.1, 8 marks. Identify and discuss John's legal position and options available to him. The guy built a house, then the house now has decided to take some of the portion of another person's jarata. Yeah, that is how the neighbor does things. Taking some piece in your jarata. Then now question number 3 here is we have to identify and discuss John's legal position and options that are available to him. What John must do. Now the person has taken some portion of your jarata, and now what must happen? Here is the answer. Do you ever heard about encroachment? Of course. Where owner encroach on their neighbor's land, the rules regarding encroachments came into operation. So here's the legal position. We start with the encroachments. A distinction is drawn between buildings and trees. Oh, then because we are dealing with the building, because that person was building. Jacob was building, was in the process of making renovation of a house. So the extension house, they went over the border. So we're talking about the building here. And then where we have the building. The owner of the land on which an encroachment has taken place can use one of the following remedies. The owner can claim removal of the encroachment. So it means that John must claim the removal of encroachment. The owner cannot, however, remove the encroachment because she cannot take the law into his or her own hands. Removal cannot be claimed if she stood by and with full knowledge of the fact did not insist on removal. The courts have a discretion in deciding whether to order removal or payment of compensation. The court can also order transfer of the piece of land encroached upon to the encroacher. The owner can claim injectment from his or her land against payment of compensation for the enhancement of his or her property. On the grounds of equity and convenience, the courts can also order transfer of the land encroached upon against payment of compensation. So number 1, he has a legal position. He has to claim for the removal of the encroachment, or he can claim for injectment. The owner can also claim that the encroacher should take transfer, or he can take transfer of the land encroached upon the pay compensation. So this one is very clear. And then you summarize all the cost of transfer, the cons of value. Then there's a tree. Then when you go to the examination, please do not forget, when we talk about encroachment, we can talk about encroachment of a building, such as house. This is the legal question of a man. Then if there is a question about the tree, you talk about the branches of a tree. This is the question. Then when you talk about the roots, this is the how you must answer. Then don't forget, when we talk about the roots, when they talk about the trees, when we talk about the building, then this is one. And I was just giving you an example. Then this is an eye-opener. So guys, this is an eye-opener. Then we know, then you get some 8 marks for telling us about encroachment and explaining the legal position of John. Explaining this thing, 8 marks. 8 marks. Easier, select this. Easier as ABC. Now, we are going to 3.2. Describe John's real relationship with the portion of John's land where Jacob's house is built. Describe Jacob's real relationship with the portion of John's land where Jacob's house is built. So you are describing the real relationship of this guy. This guy has decided to encroach the other, take the portion of your jarata, then who he is. That is what the question is asking, whether he's a real owner, whether he's a malafide, or who he is, this guy. So you have to describe the relationship of this guy, whether it's malafide or who he is, this guy. That is what the question is asking. Whether he's a real owner, whether he's a malafide. Then you get a 3 marks. Then let's answer this one. Do you remember ILW 1501? Of course. You remember when we talk about the relationship between the legal subject, who is the holder of the right, and the other legal subjects. That is what we call the real relationship. Okay? The relationship that is arising between legal subject, who is the holder of the right, and other legal subjects. Right? In this question, for an instance, Jacob think that is the owner of the house, and when the extension now is crunching to the property of John, he doesn't realize that he's no longer the owner. He still thinks that he's the owner. So they're asking about this relationship between this legal subject and who is the owner, John, the legal subject, who is the owner of the property that is encroached, and Jacob, who is not the owner, but who should be respecting this property. So the relationship between those two legal subjects. And then it's still the same. A legal relationship is a relationship to which the law attaches consequences. It's still the same. Here we have the two sides, subject and object, and we have a subject and subject. Then the question is asking about the subject and subject. And the question is asking about that one. So here's the subject and object. It's Jacob, who is the subject, and the land of John, which is the object. What is that real relationship? What's going on? Who he is? That's what the question is asking. Then you must know that there's an ownership. Ownership is the person who owns. Then we have already been told that John is the real owner. Therefore, Jacob cannot be the ownership in terms of the real relation. We have a holdership, we have a possession. Possession is when you physically control of a thing with the intention of an owner, which always is lawful and is therefore only a real relationship, not a real right. And then we have a holdership. A holdership is a physical control of a thing with the intention to derive a benefit, which may be lawful or unlawful. So now, because the John is the ownership, as the ownership of the house, of the jarata, we cannot talk about the real relationship as an ownership of ownership. Then we have to look at this one, possession and holdership. Then when you go back to the question, it is very clear that Jacob never used this one to derive a benefit. He didn't know that he's encroaching. He didn't do it on purpose to say, okay, I want to derive benefit from this without the ownership. No, he will just possess the house without even thinking. So here the answer will be the possession in terms of their relationship, and here on the down there is given in a good way. So holdership is when the person can be bona fide or mala fide. This one is related to the person who is deriving. For example, they say mala fide is when a lease who knows the lease agreement has expired but stay on. You know that your lease has expired. You know that the rent has a due, you didn't pay, but you chose to stay in the house. Bona fide. And then those bona fide is when the lease who think that lease agreement is valid but isn't. That person just think that there's a contract when there's no contract and it derives the benefit. That's what. But possession, always intention of an owner. Just have intention that I'm the owner. Bona fide possessor. Think he's the owner, but it is. So we have already answered the question now. The question is that Jacob is a bona fide possessor because he thinks he is the owner, but he is not. He did it unintentionally. It was written on the statement. So this guy is bona fide possessor. Bona fide possessor. It's not mala fide possessor. Knows he's not the owner, but he holds the thing as if he's the owner. No. This one think is a owner. So Jacob is a bona fide possessor. Then if you written bona fide possessor and then you explain what is bona fide possessor, you get a 3 marks. Easier questions, easy. Yeah. Let me. Okay, we are going forward now. Mr. Peter tried to remove a larger condenser from a shipwreck. Question number 4. That was abandoned by its owner. He tied a rope with a bio to a larger condenser in the engine room. Together with its attachment pipes and contents, the condenser weighed about 63 tons. Jackie and Jimmy started to cut sections of the condenser loose to remove and sell them. Peter alleges that he acquired original ownership of the condenser. However, Jack and Jimmy allege that they acquired ownership of the condenser. This is so simple. Peter is trying to remove a larger condenser from a shipwreck that was abandoned by its owner. He tied a rope with a bio to a larger condenser in the engine room. Together with the attachment, the condenser weighed about 63 tons. Jackie and Jimmy started to cut sections of the condenser loose to remove and sell them. Peter alleging that he acquired ownership condenser. However, Jake and Jim allege that they acquired ownership of the condenser. So all these three are fighting for the ownership. They have no one who ever become ownership of this one. This larger condenser has been abandoned, and these three now are fighting for the ownership. It's like when you find a dog, a pit bull, wandering around. No one is owner, but then three of you started to fight for the ownership, saying, I'm the first to touch this pit bull, it's mine. And the second said, no, I helped this pit bull when it was about to be bitten by snake. I'm the owner. And the other one said, no, I'm the one to discover this pit bull. I'm the owner. So, yeah, let's go now and try to find the answer so that you may be able to be helped. Do you remember in edification? Of course, you do remember in edification. Because you were writing about edification and we said that edification is part of accession. So yeah, guys, the original acquisition is when there's no owner. And then we have to identify the owner. And then derivative acquisition is when there is an owner. and that owner is selling to somebody to become owner. I think this one is a very much yeah, I think, for example, in a derivative, I'm the owner of a pit bull. I sell it to Tabo. Tabo becomes the owner of the pit bull by means of me changing the ownership to somebody else. That's derivative. I sell the house to someone, then the conveyancer register the title of the deed. It's a derivative. It's when the owner is changing its ownership for somebody. That's all. Then this one of original acquisition, nobody owns. You must be the first. People just wandering around, and then 3 people now are fighting for the ownership because nobody owns such a dog. It's abandoned. Then that is what the question is all about. I know that you won't forget when you go to the examination. Then on the examination, you dealt with a ratio. So in this question, we have to deal with appropriatio, occupatio. Yeah, that one you deal with as ratio. So this one we deal with occupatio, appropriatio. Yeah. So that's number 1 that you answer. Appropriation is defined as an unliteral taking over physical control of a thing which does not belong to anyone. Those things are called res nullius. Res nullius are things that do not belong to anyone. Just like a condenser, it doesn't belong to anyone, but which is within the sphere of a law with the intention of becoming its owner. So what are they saying is that Peter, who finds the condenser that belongs to nobody, is the res nullius, then he has intention of becoming an owner. So the answer here is very clear, is appropriatio, appropriation, occupatio. Yeah, just writing that appropriatio, occupatio, you get 1 mark. Just like that. It's easier as ABC. You get the full marks just like that. Then explain in detail who acquired ownership. It's whether it's Peter or Jackie and Jimmy. Peter or Jackie or Jimmy. This is the question number 8 marks. 8 marks which are very clear. You get the full marks. Okay. Have you ever heard about spoliation remedy? Oh, it's an alternative for interdict. So here they say to determine whether Jack has become the owner, we check the spoliation remedy, mandam van spoli, which is alternative for interdict. Then in common law, ownership of the thing is terminated by means of abandonment. When the owner abandons his property, just like a condenser, with the intention of no longer being the owner. The spoliation remedy mandament van spoli is based on the principle that the person who has been unlawfully deprived of his must be reinstated, like a jerk being reinstated, as his original state of control before the merits of the case can be investigated. To succeed with this remedy, Jack must prove that he had free and undisturbed control and that against his wish he was unlawfully deprived of such control by the spoliator. Those two. There must be a clear proof of control in a physical sense. And then they said that to succeed with an interdict, Jack had to show that he had a clear right to the condenser, that he had suffered damage or that he was threatened by irretrievable damage, and that he had no other effective remedy at his disposal. Then you explain that based on the spoliation remedy, then boom, 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 you get the marks, 8 marks, just like that. So this one, Peter must able to prove. If he proves what we were reading, then he's the one who acquired the ownership. And then Jack and Jim was a spoliator, have not acquired the ownership. It's very clear. When we're talking about the spoliation remedy, mandament van spoli. Don't forget this one, right? When you go to the examination. So I can't teach you for long. You know that the people that subscribe to me who will go on one section, those are the people that I can teach all day. So because you just watch the video, so this is where we end. Next time if my people are not wanting me so bad to teach them, maybe we can continue question number 5, but we'll be continuing with these 15 marks, and then we go on and on until then you get a clear picture of these questions. Thank you very much for watching. I hope it was very informative. We will be doing question papers, and if you are members, you are subscribed, you know that you'll be giving me the questions. Then I will be able to assist you so that when you go to examination, you will be more prepared. Thank you very much, guys. Next time.